forum for the race for district attorney in Fulton County. So we are going to welcome our three candidates. We have all three candidates here with us, and I'll very quickly lay out a few rules and we'll get started with opening statements. We have here Paul Howard, who is the current district attorney in Fulton County, serving his 6th term. Fonnie Willis is currently in private practice. She recently stepped down from being chief judge of South Fulton to run for this office. She's previously worked for 16 years in the Fulton County DA's office. And we have Kristen Wyeth, who also recently resigned from the Fulton County DA's office to run for DA. Mr. Wyeth spent 2 years at the DA's office, and he has also worked as an assistant solicitor with the city of Atlanta. So welcome to all of you. Thank you very much for joining today. We are very aware of the COVID-19 pandemic in the background of this debate and the challenge that that has really posed for our criminal justice system. I know it's something you've all been thinking about. The DA's office makes decisions that have a huge impact on the people of Fulton County. It's one of the most important elected local officials with the power to shape and change criminal legal justice policy. And your votes, the people listening, you're going to be deciding who will be the district attorney. So that's why we're so glad everyone's here to talk with us this afternoon. In terms of our rules, we are going to have an opening statement from each candidate, and then we're going to move to a question and answer format. I have a few questions, answers will be timed, and then we have some questions from the community that have been submitted to us. We picked randomly to determine the order in which the candidates will deliver their opening statement. And everybody will have 2 minutes for their opening statement. So let's see if I have, and there will be 2 minutes for a closing argument after our questions. Okay, since we're starting late, I want to roll through this. Ms. Willis, you're going to go first. So go ahead, you have 2 minutes for your opening statement. Wait, I think we need to unmute you, or at least.
Hello, can you hear me?
Yeah, I can hear you. Go ahead.
All right, great. Hi to everyone who has taken out their day today to join us for this forum. I am so happy that this is an important enough event for you to tune in. My name is Fonnie Willis. You spell that F as in Frank, A-N-I. Last name is Willis. And I am running to be the district attorney of Fulton County because I desperately believe that our community needs a change. I think our community needs a change because the way the office is currently working is not working. It's not working for those that are charged with crimes due to the way the cases are processed in that office. It's not working for the victims of crime, and community certainly feels less safe. I am hoping that everyone is paying attention. Unfortunately, with the current issues that are surrounding the district attorney-elect, there is a distraction. There is a loss of belief in the fact that that office can get things done. And I am asking that people tune in, really listen to the questions and the answers today. And on June the 9th, or if you're going to early vote, that you will vote early for Fonnie Willis for district attorney. Thank you.
Mr. Howard, please give us your opening statement.
Good afternoon. My name is Paul Howard Jr. I am a Morehouse College and Emory University law school graduate. And since I was 14 years old, when I was able to witness the humiliation of 2 African-American men in a South Georgia courtroom, I've always wanted to be a prosecutor, hoping I could create a system where no one would be embarrassed in court based upon race. In 1997, I was elected as district attorney in Fulton County. I was elected during a time when crime ran rampant in our community. We had more than 280 homicides, and we were called the murder capital of the South. The criminal justice experts said that this crime rate would never be reduced until we had a more effective DA's office. I made the simple promise that I would work to stop the violence, and look what has happened since that time. The violent crime rate in the city of Atlanta has dropped by 70%. There are 6 of the Fulton County communities are now recognized as among the top 50 most safest cities in the state of Georgia. I am running to continue to make our county a safer place for us to live. I want to continue to prosecute the most violent and the most harmful defendants, but at the same time, I would like to provide crime prevention programs for our children and second chances for defendants that are most deserving. Now, there are three things that I plan to focus upon. Number one, to continue to focus upon, number one is violent gang activity. 36% of our violent crimes are made up from gang activity. Secondly, our juvenile repeat offender rate, it is 58%, and we badly need to continue programs like the Level Up program in my office. And thirdly, we want to continue our crime prevention programs and programs to provide second chances for people who deserve them. I'm running based upon my record of service and achievement. I have never let the community down, and I will not let you down now.
Mr. Wyeth-Smith, 2 minutes for your opening statement.
Thank you. Hello, everyone. My name is Kristen Wyeth-Smith, and there are several things that clearly distinguish myself from my opponents. Number one, I'm the product of the justice system. I grew up seeing my mom get arrested several times before she lost custody of me. My grandmother was also arrested several times, and on one of those occasions, I was present and watched police strip her down to her underwear. I have an uncle serving life for murder, a close friend who was killed in the street at 17, and several other relatives and friends who have served time. I myself was kicked out of school and thought that I was destined to be a drug dealer. Overcoming all of that real life experience to be here now far outweighs any professional experience that my opponents have simply because they are older than me. Two, I want to break away from the negative history that my opponents represent and make our justice system value people over conviction rates and money. We will no longer criminalize Black and brown skin, poverty, mental health disabilities, nor substance addiction. Instead of wasting money and manpower on these things, we will end mass incarceration and partner with community service providers to focus on treatment and services instead of sentences. We will no longer abuse our prosecutorial discretion the way my opponents did in the Atlanta public school cheating case, but instead shift our resources toward combating violent and serious crimes and work to get answers efficiently for cases like the death of Jimmy Atchison instead of locking up homeless people simply for being homeless. Three, we will partner with the public school system to be proactive in breaking the school to prison pipeline and use our prosecutorial discretion to ensure that we are doing everything to help kids be kids. Four, we will end the cash bail system, which means that poor people won't sit in jail simply because they can't afford to pay their way out. Five, we will right the wrongs of the failed war on drugs, starting by no longer prosecuting marijuana. We level the playing field in a system that has marginalized and discriminated against so many people for decades under the leadership like prosecutors like my opponents. People over conviction rates means that we don't hunt conviction by any means necessary, but we get wiser about our resources to make us better and safer. Thank you.
Thank you all for those opening statements. The coronavirus poses a real challenge for managing jails and prisons and for the people who are locked up in them, given the close quarters they live in and some of the challenges of maintaining sanitary conditions. And we have seen outbreaks at jails and prisons throughout the country. Several district attorneys across the country have changed their charging practices, especially for nonviolent crimes, to avoid what they see as unnecessary incarceration. Some have stopped requesting cash bail. We wanted to explore your perspectives on how the Fulton County DA should handle these challenges. Starting with Mr. Howard, what, if any, specific criminal justice policy failings in Fulton County have been exposed by the pandemic? And what would you do to change these policies if inside the DA's office?
Well, thank you very much for the question. Once the pandemic started in full in our county, my office moved very quickly to get ahead of the curve. Our court system closed, I believe, on March the 10th, but on March the 7th, we sent a letter to all of the police chiefs in our community asking them to change their arrest policies. What we simply ask them to do is to no longer arrest felony defendants if they were not the most violent defendants and defendants involved in domestic violence cases. All of the other defendants, what we asked them to do was to simply give them citations and not bring them to the county jail. My office very quickly formed a committee, and we started to make recommendations to our court system and ask them to allow people to simply leave our jail. On the day that we started this process, we had over 2,876 people in the Fulton County Jail. Today, our jail population is 2,300. We have recommended and had released more than 500 inmates from the Fulton County Jail system. We started with people that were over 60. We've let women out, and we've tried to ask the courts to release all of the nonviolent property-related defendants who were charged with felonies in our system. One of the things that I am hoping that our system will take away from what happens when we return. My office and I have said for many years that the population of the Fulton County Jail should be less than 1,000. I'm hoping that now our criminal justice partners have finally figured out that that is possible if we work together to make sure that people are not needlessly sitting in the Fulton County Jail.
Thank you very much. Mr. Wyeth-Smith, just to repeat the question, are there specific criminal justice policy failings in Fulton County you think have been exposed by the pandemic? And what would you do to change those policies in the DA's office?
The cash bail system. I think it's a glaring example of how that system has failed. Cash bail was implemented to ensure that someone will return to court, but throughout history, we have seen that system disproportionately discriminate against Black and brown people and against people from low income backgrounds. And we have seen across the country thousands and several thousands of people sitting in jail simply because they can't afford to pay their way out. And so before this pandemic happened, Mr. Howard would not have implemented those changes that he just suggested. So I'm the only candidate who is committing to making sure that that's how the system works each and every day, by taking that system out of place and putting in a better system like those used in San Francisco, like those used in Washington, D.C. There are other cities that have shown that taking cash bail off the table is a more effective way to ensure that people return to court, so that we don't have so many people sitting close quarters like they are in jails now, helping exacerbate this pandemic, because those people are in contact with the people who work in the jail, who you and I see out at the grocery store every day, putting us further at risk. So I'm the only one committed to taking that off of the table once we come out of this thing and once I get elected.
Thank you very much. Ms. Willis.
The DA did not answer your question, first of all. So the first part of your question is, what did the pandemic expose? And what the pandemic exposed was a complete breakdown in the process. I believe he said there was 2,876 people in the jail. If cases were processed in the Fulton County, through the Fulton County system correctly, you would not have that many people in jail. Let me tell you why. One, if you were really processing them and putting the resources, and the resources, of course, being qualified attorneys and qualified investigators to do case intake, what would you find? The first thing you would find is many of the cases that he charges should not be charged. That, of course, would alleviate people from the jail. The second thing that you would find is those people that we could put into programs. One, the pre-indictment diversion program I plan to start, and into some of the mental health and drug courts that I plan to utilize, would also not find themselves in jail. And so what it exposed is that the Fulton County Jail is so overrun that they have people sleeping in canoes. And now we see that it is overcrowded. And so you did a a knee-jerk reaction and just trying to allow people to be out. But what the pandemic has exposed is a systematic problem in the way that we are doing business. And we could have cost taxpayers a lot less money if we did not have all those people in the jail to start with. Mr. Wyeth Smith is right. He is very distinguished from me. He has no experience. He has never tried a felony case. He has never managed a large office, and he simply does not have the experience to do what is needed or to know the resources that are needed to effectively implement change. It is time for a change. The way that the system has been running is unjust to so many people. We now have people that linger in jail and cases are dismissed at the time that they are called for trial. When they had just been properly evaluated at the onset, they would have never been there. And so the pandemic has exposed all of that. And it is not correct to let people out of jail that are a danger to society. And so you need the proper experience to know what to do. But let's remember, when people are at the Fulton County Jail, they have not been convicted of anything. Jail is only to ensure that you return there. And so we shouldn't be keeping people there in mass numbers anyway. I would implement a system of, if you really are concerned, perhaps we could use ankle monitors. That would save tax dollars, hundreds of thousands of dollars. They've exposed at a lot of different levels how broke the current system is.
Thank you all. I'm going to move to the next question. COVID-19 has made people vulnerable, especially if they don't have stable housing or sometimes if they have mental illness or substance abuse problems. Many of these populations tend to be overrepresented in any time in the criminal justice system because counties lack the necessary crisis response and healthcare resources to appropriately address their needs. Starting with Ms. Willis, what specific steps would you take to ensure that a person's lack of stable housing or poverty doesn't affect how they interact with the criminal justice system? And what steps would you take to ensure that mental illness and substance abuse is sufficiently addressed?
Thank you for the question. Well, the first thing is I want to be really clear because I know you are probably very educated on the criminal justice system, but some of our listeners are not. And so I want to be clear. The district attorney does not prosecute misdemeanors or city ordinance violations. I think that's an important distinction to make because you're absolutely right. A lot of people that are faced with poverty issues do find themselves violating what are city ordinances and find themselves violating misdemeanors. I don't want to overstate something or promise something that I cannot give because that office would not be the prosecutor that would impact those particular cases. I don't want these gentlemen to tell you, oh, we would solve that. And it's not even a case that they would see. That is something that the solicitor in our county would see or the solicitors that are prosecutors in the different cities. Now, as far as the mental health component and the drug program, I think that this is a huge issue and it's even a huge issue in felony cases. I plan to employ at that case intake section some social workers and work with some of the diversion programs to immediately get those people resources. Because what we know is that if people have a drug problem, you are going to see them fit into that repeat offender because they're trying to feed that addiction. You're going to see the theft crimes. You're going to see the one-hit wonder drug crimes that we should not be keeping people locked up. You're going to see the drug paraphernalia crimes that I don't even believe really should even be prosecuted. You shouldn't even bring felonies for that. All of that will answer your first question in alleviating the jail population. But also, if you get those people resources and work on their problems and understand that that drug addiction is just like someone having cancer, and until you fix the ill, they will repeatedly go back in. And so my programs will focus on making sure that those populations' issues are addressed so that they can be restored into society and not find themselves in the cycle of the criminal justice system.
Thank you for that. I just want to remind everybody, not a rebuke at all, but just remind you to stick to 1-minute answers for your questions. Mr. Howard, why don't you take the next crack at this question, which is about the problem of criminalizing homelessness and poverty and how to make sure that problems regarding substance abuse and mental illness are adequately addressed.
Thank you. One of the things that happened when I started as district attorney, this was a severe problem in our community. We had over 4,800 people in the Fulton County Jail. We put together a program called the Complaint Room, and we have now reduced the jail population to 2,400. but we still got some big issues in our community. And one of those big issues is mental health. The mental health facilities that formerly existed in our county simply are not there anymore. So we have been working together in our criminal justice system with our criminal justice partners to try to develop means to remove mentally ill people from the Fulton County Jail. So we've got a system of accountability courts, and one of them is a mental health court that we have used to divert people from the Fulton County Jail. One of the things also that is clear about the Fulton County Jail, we are handling more serious felonies. And I know people make reference to one-hit drug cases. Those are not the cases that we indict in our office. Those are not the people that are in the Fulton County Jail. When you look at the people that are there, only about 17 or 18 of them are in jail who have not been indicted, meaning their cases have already been reviewed by a grand jury or charged through the accusation process by the district attorney. So what we see is we've got some systematic problems in the community that we have to work on. And I believe that the major thing that needs to happen in our Fulton County system is that we have to make some systematic changes having to do with case processing standards, which are not under the purview completely of the district attorney.
Thank you very much. Mr. Wyeth-Smith?
In 2011, Seattle, Washington implemented a program where people were arrested for certain quality of life charges like drug possession or prostitution. They were allowed to be aligned with services through community providers to help break them out of that lifestyle. I had the opportunity to go out to Seattle to study this program in 2018, where they've had over 500 success stories. And now these people have jobs, they have apartments and homes of their own. They're not on the streets, they're not committing crimes. Employment rates are going up, property values are going up, crime rates are going down. So in terms of a best practices model, I'm committed to implementing a system like that here in Fulton County, where we're dealing with these low-level drug possession crimes. A lot of times you'll see folks struggling with mental health disabilities or homelessness who may have drugs on their person when they interact with police officers. So instead of us continuing on this system of mass incarceration by throwing those folks into jail, expecting for the jail to cure their mental health disabilities or to fix their substance addiction or to remedy their homelessness, I want to partner with community service providers like PAD, pre-arrest diversion here in Atlanta, like the VA for our military veterans who come through the system, struggling with mental health and substance addiction. There are a lot more community resource providers that we can work with on the front end to make sure that we're using our resources wiser to help break people out of the system instead of them keep coming back through on this hamster wheel revolving door cycle like we know now.
Thank you very much. I'm going to turn now to one of the highest profile prosecutions in Fulton County. In 2013, the DA's office prosecuted 35 Atlanta public school educators, all but one of whom were Black, for allegedly changing wrong answers on students' standardized tests. Some agreed to lesser charges. 12 went to trial for racketeering. That's a felony charge that's often used to prosecute organized crime like the mafia. You might know that kind of charge by the name of RICO. That's the acronym for it. There were 11 educators who were convicted, and most of them were sentenced to prison. Mr. Howard, it was your office that prosecuted those cases. Ms. Willis, you were the lead prosecutor. Mr. Wyeth-Smith, you have recently criticized the DA's office for its handling of this whole matter. Mr. Wyeth-Smith, let's start with you. How would you have handled this case if you had been the DA?
Well, first of all, prosecutors have this thing called discretion. And I don't think either of those two used their discretion wisely. I think that they were on a witch hunt and they made that set of circumstances fit RICO instead of figuring out a way to more effectively handle that case. First of all, I don't think it should have ever even been a felony. I think it's something that the Board of Education could have handled in-house. But let's say it ends up in my office as DA. I don't think that the way that prosecution handled was fair or just. there have been accusations of cheating by teachers in other cities and other states across this country. No other place led felony prosecutions like that that Paul and Fonnie did here. So I think that that was a perfect case where a diversion could have come into play, where something else could have been done to make sure that those teachers learn their lesson for what they took part in. I'm not excusing what they did. There were children hurt here, but I don't think it rose to the level of felony prosecution. That case took several months long. It wasted millions of tax dollars that took away from fighting more violent and serious crimes. This is a perfect example of what I mean by people over conviction rates. They sought conviction by any means necessary on that case, and that's not justice. Our job as prosecutors is not to seek conviction. It's balance, fairness, and equity, and they failed to do that in that case.
Thank you very much. Ms. Willis, if you had it to do over again, is there anything you would have done differently in your prosecution of that case?
Well, first I want to deal with the question. You mentioned that it was charged under RICO, and that RICO is typically used for mafia and gangs. And I do think that that is a word that lay people hear with that. But just so that we are clear, that statute is actually used primarily for corporations, and the Atlanta Public Schools is a corporation. And so I do want to deal with that technicality just from the front. Also, we need to realize that there were thousands of children hurt. I hear people that they are very concerned about that case. They think that it put a smudge on the Black middle class and Black educated people. And I've been very disappointed at some African-American professionals, because what I always hear and what I have heard repeatedly is that those children weren't going to be anything anyway. Those children didn't matter. And I take much offense to that. African-American children that grow up in poverty, they absolutely matter, and they absolutely can be something. And it doesn't matter where you come from, you can still finish very well. But most of them are going to be football players. They're not going to be NBA players. Most of them are going to find themselves in a better situation based on the education that they receive. And so the importance of that case always needs to look at the children. One thing that was offered, and one thing that I would continue to do, is pretrial was offered for hundreds of teachers, and they admitted to the things that they did. And I would never have prosecuted the teachers, but the higher ups that really punished a lot of single mothers, which I am, the higher ups that had them saying, if Johnny can't read, Johnny better read on test day, taking millions and millions of dollars from these children who could have benefited from this federal money. I just want to make sure that society remembers at its base that children were hurt, and that when you are a prosecutor, you are to protect the most vulnerable, and children, the elderly, and the poor, they will always be the most vulnerable.
Thank you. Mr. Howard, same question to you. Is there anything you would do differently if you were to handle this kind of case again?
I would not do anything differently. This case, from the perspective of our office, from the beginning to the end, was simply about children and education. There are some factors that I think that people should always realize about this case. And one of those factors is 256,000 wrong to right answers. That's the case that we prosecuted. 256,000 wrong to right answers. The next year, the supervision of those tests was turned over to the state of Georgia. And when that happened, we only had 100 or less changes from wrong to right. There's a second thing that I think that people maybe don't realize in this case, but the superintendent of schools in Atlanta, my office actually met with her at the home of Ambassador Andrew Young. And she, at that time, indicated that she wanted to enter a plea. We attempted to get the judge to take the plea. The judge would not do it. So the very person that we alleged was at the top of this conspiracy agreed to enter a plea. I have been amazed that people keep using the phrase mafia with the charging device that we use, because I think if you sit and think about it, when is the last time that anybody has charged the mafia? And generally, this crime has been used to prosecute drug offenses gang offenses. And the reason that we used it is because of the exact nature of the crime, a corrupt enterprise. And that is exactly what it was. It deprived children of their most basic right, and that was the right to education. In fact, the vestiges of what was happening during that time are still hampering our communities, because some of the children whose tests were changed now are in high school. And if you look at those high schools who were once outstanding high schools, they're now failing high schools because of those same students. So no, I would not go back and change anything. I think the thing that has changed now, our system is better. This changing test is not happening again. And I believe that our office is partially responsible for that significant change in our community.
Thank you all for those answers. I'm going to turn to a question about the Fulton County jail system and cash bail. The Fulton County jails were under federal oversight for 10 years, which is much longer than most oversight cases. Some of the issues that led to that oversight were overcrowding that was so bad that people were sleeping on the floor, and raw sewage flooding the cells. So now we're in this time of the pandemic, and we've been talking a little bit about getting people out of jail. We have a question that comes from Mary Hooks, who is the co-director of Southerners on New Ground. She says that a common scenario in Fulton County and elsewhere is that somebody gets arrested and the DA's office won't agree to letting them out on their personal recognizance, just letting them out without bail. Instead, they're held on cash bail, which they are too poor to afford to pay. And they can be held pre-trial for weeks or months. Then the DA's office offers them a deal. Either you plead guilty or you'll be sentenced to time served and released. Rather than stay in jail waiting for a trial date, which can be far off, there are a lot of defendants who agree to plead guilty because it's the quickest way for them to get home to their families and jobs. So Mary Hooks asks, if it's safe to release someone from custody at the point when they plead guilty, why can't they get released earlier on before having to spend weeks or months in pretrial detention? And what do you think about whether the system that Mary is describing deprives people of their constitutional right to trial based on whether or not they can afford bail? Ms. Willis, why don't we start with you?
First of all, I think that if cases were evaluated properly, the DA talked about this case evaluation process that he does. There is no case evaluation. The police make an arrest, and for the police officers to arrest, they need to find probable cause. For lay people listening, that is a very low standard in the law. But if they do find that, they can arrest. And then those charges are taken to the district attorney, and then an indictment is drafted. That is the time period that the young lady who asked the question is asking about, of people just sitting in jail. Then once you get past indictment, then they're waiting so that they can get to a courtroom assignment and to a plea and arraignment date. And at that plea and arraignment calendar, she's talking about, at that point, they're made an offer, and then some people take the offer, as she said, to get out of jail. One, I think the cases should be properly evaluated. And I don't just want to use that as a word. I want to talk about what I mean. I mean, we would put our most experienced investigators and lawyers in there so we can decide if the charging is proper. I do think that unless it's a violent crime, or unless we're worried about them getting to a domestic violence victim or them not returning to court, I believe that people should have a bond, and maybe that's the defense attorney in me, but bond is only to make sure they can return to court. And of course, I believe they should have their right to a trial.
Thank you very much. Mr. Howard, we're talking about the constitutional right to trial and the ways in which not being able to afford to pay cash bail may be impinging on that right.
Well, I do want to note that Mrs. Hooks, who asked the question, actually sat with our office to evaluate cases for release. And I don't believe there's any other place in the country where they've invited people from the community to actually sit down with prosecutors and review cases for release. But I believe that the example that Mrs. Hooks has provided as the typical kind of case in Fulton County is simply not correct. I think if you look at the great majority of the defendants in Fulton County, one of the problems is that a great many of them are repeat offenders. Our judges are legion and famous for giving the smallest release criterias and bonds of any people in the state. In fact, the criminal justice system in our county is greatly assailed by the public for letting people out, not keeping people in. But I believe the focus maybe is on the wrong agent. People talk about the jail. I believe the problem is the system. If you look at the top 45 cities or jurisdictions in the country with populations of 1 million and more, Fulton County has simply refused to follow best practices. One of those best practices is you've got to have a case processing standard. That case processing standard would move people out of the jail a lot more rapidly. That does not happen now, but with respect to cash bonds, what our court system has done is they've used something called a signature bond, which means that there is no bond at all. And the example that Mrs. Hooks gave might be a rarity, but it is certainly not the majority of defendants at the Fulton County Jail.
Mr. Wyeth-Smith, how do you see this issue of cash bail that people cannot afford affecting whether or not they plead guilty?
Well, let's talk about the cash bail system and its impact on throughout history. So when someone's sentenced in jail simply because they can't afford to pay, and we all know that disproportionately that has been Black and brown people and people from low income areas, then they will lose employment if they are employed. After you lose your job while you're still sitting in jail, you lose your housing. So losing those two things, that actually plays into repeat offenders and recidivism. If somebody's sitting there and they lose everything simply because they can't afford to pay when they get out, once they finally do get out, what do they have to go back to? They have no job, they have no house. So a lot of times those people resort back to criminal activity just to survive and just to eat. And so I want to be clear, I'm the only candidate in this race who has said clearly that I will never recommend a cash bond once elected. I think that system has discriminated against people for decades, and no one has ever stepped up to challenge that system. And so that's what I'm doing here in Fulton County. And it absolutely plays into, I would say, the mental aspect of why sometimes people enter guilty pleas when they may not, where the evidence may not be there, or there may be no other reason for them to plead guilty other than they're wanting to get out. So to address Ms. Hook's question, yes, I do think people plead guilty just to get out of jail, but we could have took that, we could have handled that better on the front end by not recommending a cash bond in the first place, especially for the low level and non-violent offenses. Specifically, I can remember a case I had at Fulton County. A homeless guy stole a $1.50 pack of cheese crackers from Family Dollar. He was given a $10,000 bond. He stole a $1.50 pack of cheese crackers. There's no way he can afford to pay a $10,000 bond. So that means that guy was going to sit in jail for upwards of 90 days. And then he's already homeless. So once he gets out, what's going to happen? What services and treatment are we putting in place to try to help him break out of the lifestyle that got him there? So I am the only one who has given a clear answer that that's what I plan to do, is no longer use that system. And I want to make this clear. I have not taken a single donation dollar from anybody in the cash bond industry, and I will not.
Thank you very much for all those answers. We are getting close to the end of our hour, so we're going to move to closing statements. Mr. Wyeth-Smith, you're going to go first. You have 2 minutes for your closing statement.
Oh, there's some alert popped up on my screen from the host. I'm sorry.
No problem. We'll count them now.
Well, thank you all for giving me the opportunity to speak to you about my passion and my vision for the justice system. I am the most progressive candidate in this race, and I'm that way for several reasons. My background is completely different than any of the other two candidates, and I would dare say any other DA across the country, Because of the things I overcame during my childhood, I have the unique ability to connect to root causes of crime to help us combat crime in ways that have never been done. I've also stood firm in calling out the elephant in the room. Our justice system is rooted in racism and discrimination, and nobody has ever stepped up to challenge that. I've been frustrated the entire 37 years of my life about why nobody stepped up to address it. Well, I'm here now, and I'm not going anywhere, and I won't go quietly. And I speak on behalf of the people. I'm not talking to you like an elected official. I'm not giving politically correct, middle of the road answers. I'm standing up for the people who don't have a voice, the people who have been taken advantage of and discriminated against by a system that was designed to treat people fairly, but has not. And so it's time for us to make our system value people over conviction rates. It's time for us to get off the hamster wheel of mass incarceration. And if you are bold enough and willing enough and want to take that leap with me to make our system better and give people opportunities and help us thrive, that's how we make us safer. So wise up, vote Kristen Wyeth Smith on June 9th, at @WyethSmith2020 on Instagram, WyethSmith2020.com. I'd be honored to serve as your next Fulton County District Attorney. Thank you all.
Thank you for that. Mr. Howard, it's your turn for your closing statement.
Fulton County, a $1.35 bag package of crackers is a misdemeanor not prosecuted by the DA's office. But I would like to thank you all for hosting this forum today. I ask the voters who are listening to this that they would consider my record of service to the Fulton County community. I believe that one of the greatest measures of this service is reflected in the 40 judges and 3 elected prosecutors that were former assistant district attorneys in the Fulton County DA's office. I'd like to ask you to remember the 3 things that we're going to continue to focus upon. Violent gang activity, number 1, drive-by shootings, slider crimes, our juvenile repeat offender rate, which is 58%. And the 3rd thing is continuing to provide crime prevention programs for our children and second chances for deserving defendants. I also want to mention again that my heart goes out to all of the victims of the coronavirus, particularly those who've lost family and friends. And I think that one of the things that we can all agree upon, if our leadership in this country was better, we would not have gone through such troubles. That's what I bring, experienced leadership, and I would ask you to return me to service. Thank you very much.
Thank you very much for that. Ms. Willis, your turn for a closing statement, please.
Thank you. My name is Fonnie Willis, and I am asking for your vote on June 9th, 2020 or before. The reality is I am the only one of these 3 gentlemen that bring integrity back to the district attorney's office. Let's talk about the elephant in the room. The reality is, Democratic voters, you have a chance to put the DA in office. Right now, you should be very concerned that if the current DA gets elected, he will be removed under the allegations he is facing. That is thing number 1. Thing number 2 is what Mr. Wyeth Smith flaunts to you is that he is experienced based on his life experiences, and he challenges the life experiences of me and the other competitor, having no knowledge of them. He is not the only one with the family member that has been charged with murder or has been accused of murder, but that's not what makes me qualified. What makes me qualified is the 24 years of public service I have done. The fact that I have represented people charged with crimes, and I have represented people charged with the most serious crimes. The fact that I have tried over 100 murders, that I have represented defendants that had their assets wrongly taken from them and challenged the police and won. It is my wealth of experience over 24 years in serving this community that make me qualified. And I am asking you to elect me based on that experience, based on the fact that you want a leader that you can believe in and has integrity. And the last component is compassion. The current district attorney has not ruled with compassion. And as a result, he has not been able to keep qualified employees there. And more importantly, he has prosecuted too many people that he could have simply put into diversion programs and restored back into society. Please don't waste your vote and vote for the only qualified candidate with integrity on June the 9th, Fonnie Willis. Thank you.
Thank you all so much for participating, and all of you for listening. I hope this gives you a sense of your candidates and your choice. This concludes our forum. A reminder, primary election day is on Tuesday, June 9th. If you're voting by mail, your ballot has to be received, not postmarked, by June 8th. Thank you all so much for being part of this forum, to Mr. Howard, Ms. Willis, and Mr. Wyeth-Smith, and thank you everyone for joining us.